We actually started out talking originally about guardianship. So both Cindy Friedman and I do some guardianship work, which often involves the public guardian and trustee, and often involves adult protection. And uh, so Cindy does that kind of work from the government side. I've been doing it on the private sector side, and uh, but I also immediately said, "Hey, we should talk about how you avoid reading a guardianship order." And one of the ways is by using these planning tools. So. One of the most important, in my view, is the enduring power of attorney. I'm going to talk about four different things that people can do today: enduring power of attorney, advance directive, representation agreements, and supported decision-making agreements. So these are all tools that can be very useful for people who are not able to make decisions for themselves or need assistance making decisions. The first one, and the one that I do a lot of, and that lots of other lawyers do a lot of, and it's good. Really good thing is the enduring power of attorney. So we use the Enduring Power of Attorney Act. That's legislation that came in actually about 25 years ago. And we'll talk a little bit about the fact that it's been amended recently, but the amendments have not come into force yet. With the enduring power of attorney, when somebody makes one, the grantor, the person making it, appoints one or more decision makers or decision maker or alternates to make decisions for them. It's the legislation, I would say, is very good. It's really clear. It sets out what the requirements are for a valid enduring power of attorney. The grantor must be an adult, must be written and dated. It must say, the document must say that it will endure despite subsequent incapacity. So a traditional power of attorney only operates if the person who made it has capacity, but an enduring power of attorney can continue in effect even if the grantor loses capacity. It incorporates the explanatory notes. So these are a list of notes. It's about two-thirds of a page of notes that are actually included in the legislation, and they are included in every single enduring power of attorney. They are essential for its validity. Right now, at least, number 5 is also true. There must be attached to the enduring power of attorney a certificate of legal advice signed by a lawyer. This is one of the things that's changing, but that is currently the requirement. The legislators, when they made this, decided that it was very important that the people get legal advice prior to making these documents. The donor must understand the responsibilities and consent in writing to the appointment. Sorry, I see that the person who is being made the attorney must understand the responsibility and consent in writing to the appointment. Actually, that's a mistake in the PowerPoint. So the person making the power of attorney must receive legal advice, and the person who's being appointed as an attorney must confirm in writing that they understand that responsibility and consent in writing to the appointment. The enduring in that term, enduring power of attorney, refers to the fact that it will not be terminated by the subsequent incapacity of the donor. So that's unlike the traditional power of attorney, which operates like a principal and agent relationship, where if you have a principal who's incapacity, the agent no longer has authority. That's not true with the enduring power of attorney. And in fact, most enduring powers of attorney are what's sometimes described as springing. They only will come into effect on the grantor's incapacity. So the term that's used in the legislation is mental incapacity or infirmity. It's not defined any more than that. Section 4 of the Enduring Power of Attorney Act, though, says an enduring power of attorney is void if, at the date of its execution, the donor is mentally incapable of understanding the nature and effect of the enduring power of attorney. So I say you could probably look to that, to what you would look for in terms of determining mental incapacity later, if that's what you need for the enduring power of attorney to come into effect. Section 7 of the enduring power of attorney permits the release of confidential information by healthcare professionals authorized to address the issue of capacity. This is really important because if it's a springing power of attorney, which almost always are, I'm going to say over 90% of the ones that I make only come into effect on the mental incapacity of the donor, then you need somebody down the road to say the donor is incapacitated. They don't have mental capacity now. The default is that it's a healthcare professional, and this section 7 of the legislation, authorizes them to release information that would otherwise be confidential for this purpose to address the issue of capacity. Section 6.4 of the Act creates the default for who determines capacity. It's two medical practitioners or a medical practitioner and a nurse practitioner declare in writing that the specified contingency has occurred. And the specified contingency is almost always the grantor's incapacity. I'll mention at this point that that is not who you have to pick. That is the default that I put into my enduring powers of attorney that I draft for clients. But you can say that it's somebody else. You can say that it's a friend. That you can say that it's a spouse. The declarant doesn't need to be a medical practitioner, and it can even be the attorney themselves. I typically say that people should at least consider that it be the attorney and one other person. There's no strict rules on this one, and it often is better if it's somebody that's closer to the grantor, in my view, someone who sees them day by day and will have a better idea of at the point where they need the assistance of their attorney. It's good practice to detail what information is to be included in that declaration. So remember, somebody will have to declare that the grantor is incapacitated. And so in the enduring powers of attorney that I make, I say this is the specific pieces of information that need to go into that declaration, and just to make it easier for that person and make it easier to show that the enduring power of attorney has come into effect. So now I'll refer to the Enduring Power of Attorney Amendment Act was passed in December 2020, so almost 4 years ago. It's not been brought into force. One of the big changes is that the requirement for a lawyer's certificate is going to become optional. I'm going to mention that there's Enduring Power of Attorney Acts, similar legislation across the country, and several other jurisdictions have also dropped this requirement for a lawyer's certificate, most notably Ontario. But what they've done and what is the plan to do here is that they are making the forms and the regulations much more detailed. So the alternate when the new legislation comes into force is that instead of there being a lawyer's certificate, that the execution must be before two witnesses, one of whom will sign a certificate, and the enduring power of attorney will have to be in a prescribed form. The prescribed form and the regulations will give a much more direction to the attorneys. And some of that direction, I'm going to point out, reflects the history of financial abuse by attorney. And I'm going to bring that up now because that has been an issue for as long as that legislation has been in effect. I'm going to say it was an issue before the legislation came into effect. The enduring power of attorney is a way for a person to pick the person that they trust the most to make financial decisions for them. And we do, to some extent, to a large extent, trust the decisions that the grantor makes. And it is unfortunately the case that, of course, at the point when this person is most vulnerable, when they've lost incapacity, that attorneys, unfortunately, do sometimes abuse the decision-making power that they've been given. So it's something that you do have to warn your clients about. It's really important that they appoint somebody who is very, very trustworthy. Advanced directives. So an advanced directive is a similar sort of document to the enduring power of attorney, but it's for a different kind of decision. So the enduring power of attorney is for financial and property decisions alone. And it's made under the Enduring Power of Attorney Act. An advanced directive made under the Care Consent Act, and with it, the maker appoints one or more proxy. So that's the term that's used, a proxy or an alternate to make care decisions for them when I am no longer mentally capable of making my own care decisions. So I've got this little booklet here. I'm going to hold it up. Lots of people have seen this booklet before. It's really good, in my opinion. It's called planning for your future healthcare choices. You can download it off of the government's website. It includes in it what's referred to as the abbreviated form, and I put abbreviated in abbreviated in quotation marks because I've never seen any other form, at least produced by the government. It's a good form. It's very straightforward. It's in it. There's a list of restrictions, so the maker could either impose some restrictions on the kinds of decisions that can be made by their proxy, um, or not. They can say they can put all of the authority into their proxy. There's actually a list of specific kinds of decisions that might be made. The It's mainly for healthcare decisions. There's no question then that the kind of decisions that are listed in the form are healthcare decisions, but it can also include more advanced decisions, including decisions like admission to a care facility and consent to personal assistance services. I think it's a really good form. I generally don't make these for clients, it's but I refer people to this information all of the time. It's my view that with respect to making advanced directives, that the more important professional for clients to get advice from is actually a healthcare practitioner rather than a lawyer. And but I recommend to people all the time, especially at the time that they're making an enduring power of attorney, that they make an advanced directive as well. The next two agreements that I'm going to talk about are ones that I do not have personal experience with, but they're types of agreements that can be made under the Adult Protection and Decision Making Act, and they authorize a person to make decisions for adults who require decision making assistance. So these are typically just adults who have limited capacity and need assistance with them. So representation agreements authorize a person to make decisions for adults who require decision-making assistance. It can be financial and personal decisions, including decisions about where a person lives, works, or school attendance. So pretty serious decisions. One of the restrictions that's contained in the legislation is the time limitation. So they can be 1 year or 3 years, and they cannot be renewed. The person needs to make a new representation agreement at that time. There's a form that's included in the legislation. Form 2 is a prescribed form under the Schedule to the Adult Protection and Decision-Making Regulation. And it includes a detailed list of decision types from which the maker can choose which types of decisions they want their representative to make for them. As with the enduring power of attorney and as with the advanced directive, the representative must agree in writing to assume the responsibilities. For that one as well, there's a booklet produced by Health and Social Services. I suspect that most of those forms are filled out by social workers. It's not one that I've ever been asked to do for a client. And then the last category that I'm going to refer to is the supported decision-making agreements. Again, that's under the Adult Protection and Decision-Making Act. And in this one, the purpose of these agreements is to authorize a person that's called an associate to assist an adult who requires decision-making assistance with making those decisions. Again, there's a form. Form 1 is a prescribed form found in the schedule to the Adult Protection and Decision-Making Regulation. This time doesn't include a list of decision types, and the maker must actually fill in the blanks for the kind of decisions that they want assistance making. Again, the associate must agree in writing to assume those responsibilities. And the booklet is produced by Health and Social Services. By the way, I realized we said that people could ask questions, and but with the screen that I have, I can't see any questions.
It's not the normal. It's not even like
The chat was disabled. Okay.
It sounds disabled, but the Q&A is open.
Okay.
If you can ask questions through the Q&A.
And I see the Q&A.
I don't know if it can be seen through your monitor, but apparently if we try to monitor it in this room, it will interfere with the presentation. So
Yeah.
he's being monitored outside the room, so we'll be advised. Yeah,
Okay. So is the Q&A on now?
it is.
It is on now. Okay. All right. And I'm going to try and get this back to the screen. Nope. Did not do it. Hmm. Okay. Lynn, I just messed it up. Let's see. Here we are. Okay. And oh, that's not it. I'm trying to make this full screen.
Okay, that's good. I can do it.
And then we're moving on to Cindy stuff now.
That's fine.
There we go.
That's good. Good enough. Yeah. I think so. Put on my glasses.
Yes.
So Lenore has spoken to you about a number of legal arrangements that can be made by an adult person while they still have capacity, while they're still capable. And I'll use mostly the language of capability because our legislation, both the Adult Protection and Decision Making Act, the Care and Consent Act, use capable, but their capacity is used in other contexts or other jurisdictions. So once an adult is no longer capable of entering into any of these various legal arrangements, what's left is guardianship. And so guardianship is obviously a much more, or as you'll soon hear, is a much more intrusive form of support. It actually allows the guardian to make decisions for the adult. And the adult is not an applicant in these guardianship applications, and the adult is not choosing who should be his guardian or her guardian. Although, as I will soon review, the adult's wishes are taken into account. So, assuming an adult is no longer able to enter into any of the legal arrangements that Lenore has just spoken about, this would be the last resort. So it's obviously much more preferable than that an adult, while capable, can choose their own form of support and who they would like to do that support for them. So guardianship, as I've already said, is under the Adult Protection Decision Making Act. Under Section 2 of that act, the guiding principles are set out, and these principles will be reflected in this slide, the ongoing slides, and very much in the law and how it's applied by the court. So all adults are entitled to live in the manner they wish and to accept or refuse support, assistance, or protection as long as they do not harm others and they are capable of making decisions about those matters. Adults are entitled to be informed about and to the best of their ability participate in the management of their affairs. All adults should receive the most effective but the least restrictive and intrusive form of support, assistance, or protection when they are unable to care for themselves or manage their affairs. And the Supreme Court should not be asked to appoint and should not appoint guardians unless alternatives, such as the provision of support and assistance, have been tried or carefully considered. The values, beliefs, wishes, and cultural norms and traditions that an adult holds should be respected in managing an adult's affairs. The next slide speaks about the legal presumption of capability. So there is a legal presumption that an adult is capable under the Act and at law. So the onus would be on the applicant to establish that the adult is incapable. Court-appointed guardians. The public guardian trustee has a publication, How to Apply for Adult Guardianship Self-Help Guide, which is very helpful, and it's available online. And this is certainly a tool that lawyers can refer their clients to, and many, many private applications are made by self-represented persons. Guardianship applications are brought before the Supreme Court. They're made on prescribed forms, and these forms are found as schedules to the regulations. The In order to make a guardianship application, these forms are mandatory, the following 5 forms. So there's the guardianship application, which will include who you're serving and which will set out what powers and authorities you're seeking as the guardian. Form 4 is the applicant's affidavit. It will include some standard language, which include matters that you have to prove, for example, that the adult would benefit from having a guardian. There's also a statement of proposed guardian. So as we'll see, there's duties that a guardian has to comply with under the Act. And this statement of proposed guardian is really just an affidavit sworn by the applicant, which says he will comply or she will comply with all of the various duties. So it's basically filled out. The incapability assessment, that's Form 6, and we'll speak more about that soon. And the Form 7 is the preliminary guardianship plan. So an applicant will have to, in this form, fill out all sorts of background information about the adults, where the adult lives, who the adult's family is, does the adult have any of the various legal arrangements that Lenore has taken us through. And then the applicant will have to fill out all sorts of information about the adult's financial situation, the adult's living conditions, the adult's ability to look after themselves. And then finally, the form will prompt the applicant to give details of plans with respect to the various areas of authority that the applicant is seeking. So if the applicant is not asking for any authority in the financial domain, for example, the applicant will not have to fill out a plan for that area. But whatever powers or authorities the applicant is seeking from the court, the applicant will have to write what their plan is in their Form 7 for the court to review. Service of the guardianship application. So the application and all the forms have to be served at least 7 days before the hearing, although there is leeway for the court to shorten that period of time. And they have to be served on the adult, him or herself, the adult spouse, if there's a child, a parent, a sibling, or a relative, at least one of them, the proposed guardian, the person in charge of any hospital or care facility where the adult is admitted or living, the public guardian and trustee. And this is a bit of a safeguard. It's a bit of a check. The public guardian trustee is given notification of these guardianship applications, and essentially they would be aware of any investigation they were undertaking if the applicant, if there had been a complaint about the applicant of financial abuse, for example. The public guardian and trustee might also check with the Adult Protection Service, and Tina Bunce is present from that service and will speak about her office shortly. And they can participate in the application. They can respond to the application and get service of all of the documents filed. And essentially, they can share their concerns with the court. They also review the application to see if they have any concerns. And then any person authorized under any of the various directives or agreements, that person would also be served. So that would be a person who had some decision-making powers at the time the application was made, or could potentially have them if, for example, a power of attorney was triggered. And you can seek guardianship for a person who is 18 years old, despite the fact that in Yukon, an 18-year-old is a minor. And the person who has custody of the 18-year-old would receive service of the application. The hearing's an informal process, and as I said before, the onus is on the applicant to establish that the person needs a guardian. So generally in these cases, there often is only one party, the applicant, and sometimes the adult herself is not even present in the courtroom. Sometimes other people will attend, and the court, for example, might hear from the adult or might hear from other parties who are other persons who attend, interested people, family, friends, perhaps the Adult Protection Service or the public guardian and trustee. And often they are not sworn in. They are just asked questions by the court. Sometimes applications can get more contentious, and in those situations, the judge might choose to swear in some of the witnesses and to allow other parties to ask them questions. But still, the process does remain informal. The test for guardianship. So the court must be satisfied that the adult is incapable of managing some or all of their affairs. The adult needs the care, assistance, and protection of a guardian, and forms of support and assistance less intrusive than guardianship have been tried or carefully considered. So incapability assessment. So this is essential. All of the forms are essential, but evidence of incapability is clearly needed. Otherwise, guardianship cannot be ordered by the court. So who's qualified to complete these assessments? It's under the regulations, they're listed, a medical practitioner, a nurse, a registered nurse, a psychologist, or an occupational therapist. An assessor must determine the incapability of an adult to manage all or part of their affairs in accordance with the guidelines for conducting incapability assessments published by the Department of Justice, and these can be found online. So these help explain the test and how the assessments are carried out. So there's no single test for determining incapability in North America. The determination of incapability is a legal determination, not a medical one. As thinking on mental incapability has evolved, definitions and tests have moved away from a global assessment primarily based on a medical diagnosis. Assessments consider medical, cognitive, and functional components. So sometimes we're in court on files where guardianship was ordered years ago before this act came into effect. And you might find that the evidence of incapability was simply a note from a doctor. So that's no longer possible. These incapability assessments consist of many different sections, and they basically prompt the assessor to answer a number of questions. And the assessor will begin by giving background information. The assessor might look at medical records. They might do cognitive testing. They might include the results of cognitive testing done by others. They speak to collateral sources, family, friends. They speak about what kind of decisions the adult actually has to make in their life, and that feeds into whether there is a need and the level of capability. So a really simple example might be that a person might be capable of giving consent to, for example, a doctor says, do you want Advil for your headache? So an adult might be able to give consent to that. They might have that capability, but they might not have the ability or the capability to manage complex financial transactions. So an assessor looks both at the adult's needs, what kind of decisions the adult will have to make, and looks at their capability to make those decisions. So in the Yukon, the test of incapability to manage one's affairs is defined in the guidelines as inability to understand, inability to appreciate the consequences of a decision or lack of decision, or inability to execute or put the decision into action. So if an adult has trouble in any of those areas, then the adult can be held to be incapable by the court. So a common form of incapability relates to memory issues, for example. Lots of people suffer from Alzheimer's or dementia. So how memory feeds into some of these tests would be if you can't retain information, then you can't really process that information and make good decisions about what you should do. And often your memory might even affect your ability to carry out any decisions you make. So the assessor will look at all of these factors and be prompted by the form to consider these factors in different areas of decision making. And generally, it's divided into 4 different domains. So financial, legal, health, and personal decisions. And the assessor will actually state their opinion of whether the adult is capable in each of those 4 areas. The assessor will also be prompted to give reasons, the basis for their opinions, and they'll also be asked to speak to the likelihood of change. Is it possible that this is temporary, that the adult will not require permanent guardianship? Suitability requirements for guardians, they have to be 19 years old. They have to agree to comply with the duties of the guardian, and that would be the Form 5. They have to sign that. A trust company with respect to financial affairs, a beneficiary under an adult's will can be a guardian. The court has to consider the adult's wishes. If he or she expressed any when they were capable, and the public guardian and trustee may act as a guardian where there are no other suitable persons available and prepared to act as guardian. So clearly the public guardian trustee would be the last resort. So when you speak about the least intrusive, then having a family member, a spouse, a friend be your guardian is far less intrusive than having a government office make all your decisions for you. So the public guardian trustee is really a last resort. I think I skipped one ahead. So areas of authority, again, as I've already indicated, you have to indicate in your application what areas of authority you're actually seeking, and the order will set those out. And they are divided between personal, healthcare, legal, and financial areas of authority. And again, the test is they have to be necessary, they have to be the most effective, least restrictive, and intrusive form of assistance, and they have to be required. There are some specific powers listed in the Act, and usually we take the language from the Act when those authorities are granted, and they deal with finances, where the adult should live, whether the adult should work, whether they should receive care, live in a care facility, and decisions about their diet, dress, social activities, and companions. Now, there are some authorities that you cannot assume are covered when you are granted guardianship over personal decisions or healthcare decisions or financial decisions. These are authorities that you have to ask for specifically. So when you're doing your guardianship plan and you're planning for a client, and you know there will be, for example, a need to sell an adult's home. So quite often a person is on the verge of requiring a care facility when guardianship applications are made. So part of your plan might be to move the adult into a care facility. At that point, you know that the adult might be leaving their home and no longer require the home. You might want to sell the home. So that is an example. Selling real property is an example of where you need the court's express authority. And I've listed some of the others: to sell a business, real property, I've already indicated, leasing an adult's real property for more than 3 years. And one of the authorities that you need to have specified in your order is to dispose of the adult's personal property that is worth more than the amount prescribed by the regulations. There is actually no amount specified in the prescribed by the regulations. However, in the guardianship plan form, in Form 7, the applicant is prompted to indicate whether they plan to sell any of the adult's personal property worth more than $2,000. So you can read this slide for more information. You can also see that a guardian cannot be given authority to give or refuse consent on the adult's behalf to health care. That's excluded under the Care Consent Act from a substitute decision maker. This would rarely come into play. It's things like non-therapeutic sterilization or abortion without written recommendations from healthcare providers. So it's not really that relevant in most applications. I'm good. Just checking on my time. Duties of guardians. So the guardians do have many duties. So if you are granted guardianship, you cannot really just go off and say, okay, now I'm going to make decisions like I would make for myself if I was in similar circumstances. You do have some duties you have to comply with, and specifically, you do have to consider the adult's wishes. So a guardian must act honestly and in good faith, exercise the care, diligence, and skill of a reasonably prudent person, act within the authority granted in the court order, and encourage and assist the adult to care for and make decisions about themselves and manage or participate in managing their own affairs. So the adult remains a part of the decision-making process. So when managing an adult's financial affairs, the guardian is a fiduciary. Guardian must not dispose of property other than the money that the guardian knows is subject to a testamentary gift in the adult's will, unless necessary. A guardian has a duty to consult with the adult and comply with their wishes if known and reasonable. A guardian also has a duty to keep records and report. So a guardian has to keep accounting records. The public guardian and trustee or the adult themselves can ask to see those records, and the guardian has to report. So for example, there's a mandatory Form 8, which is an inventory and account that all guardians have to fill out within 6 months of being granted guardianship. So this is really an update to your Form 7, your guardianship plan. You have to indicate you've now been guardian for a number of months. You have better probably knowledge or familiarity with the adult's financial situation. Other things have changed with respect to personal health care. And so you update the court on all of these, all this new information, and you also provide the court with an updated plan. There is also an obligation following that Form 8 to report to the court any new liabilities or assets that come to your attention. You could ask to have this waived by the court as well. A guardian also has a duty of confidentiality. So while acting as guardian, you may come into possession of a lot of personal information. And you are required to keep that information confidential. You gather only that information that you need. And once you don't need it anymore, you are not supposed to keep it. And of course, you're not supposed to share it. On an interesting related point with service, we've run into situations where one of the people that should be served when the PGT is making an application is actually an estranged family member, somebody who's not really interested in the application, but the act requires us to serve that person. So we have gone to court, sought a desk order allowing the public guardian trustee to serve only the application on that person and to not from the start serve all of the other forms. And we've said to the court that if that person then shows interest and wants to be a party to the application, at that point, we can provide them with all the other information, because these forms do include a lot of personal, financial, and healthcare information. My next, okay, so my next two slides are there. They're not, they come up rarely. There is the possibility of seeking temporary guardianship of up to, I was going to say 3 months, but it looks like that's 6 months of an adult, that's only with respect to financial affairs, and that really just buys you some time to complete your documents to apply for permanent guardianship. A court can appoint more than one guardian. When they do, they specify what area each guardian has authority over. That has to be clear. And a court can also appoint an alternate guardian, and in that case, they have to make clear the circumstances in which that alternate gets to assumes guardianship. And finally, this is just here for your information, particularly as lawyers. There is something called statutory guardianship, and this is found under the Public Guardian and Trustee Act. And this is triggered by a healthcare worker who or a care worker who completes what's called a certificate of need for financial protection under the Care and Consent Act. And this certificate of need for financial protection basically gives the healthcare worker's opinion that the person in question is not capable of making a healthcare decision and is not capable of managing their affairs, their financial affairs. This certificate is provided to the public guardian trustee. When the public guardian and trustee receives that, they may, under the Public Guardian and Trustee Act, issue what's called a declaration of statutory guardianship, and then they become the adult's financial guardian with all the powers they require to manage the estate of the adult. For up to 60 days. If in some cases it's less, it's a maximum of 60 days. So for example, if a person is a patient in a coma and a certificate of need is issued for that person, if they come out of the coma, clearly that would be the end of the statutory guardianship. Otherwise, if statutory guardianship is required for more than 60 days, then a new certificate of need is provided by the healthcare worker if they continue to believe that the adult does not have capability in the required areas. So I'm mentioning this mostly because this is often a gateway to the public guardian trustee. This is quite often how adults first come to the attention of the public guardian and trustee. Some adults might have a fall and they end up in the hospital. And at that point, they interact with a doctor, a social worker, or someone else. And quite often, statutory guardianship leads to a guardianship application. Now, the first thing the public guardian trustee does is contact family and other interested parties to see if to explain to them the process, what's involved, and see if they are prepared to act. So I think I've used all my time. Thank you.
Thank you, Cindy and Lenore, for leading us through any legislative provisions. We're now going to before we go to our next speaker, we're going to take just a momentary break just to deal with a technical issue. So just bear with us, have a sip of water, look out the window, check your email. We'll be back shortly.
So I don't have any slides. I'm just going to speak from some notes here. Just to give you a little bit of information about the office, as Tom mentioned, I'm part of the Department of Justice. We're located physically in the courthouse on the main floor, right beside land titles. When we're fully staffed, we have 5 people in the office, including myself. We currently have about 122 active files, which include estate files, adult guardianship files, official guardian files, statutory guardianships, and minor trusts. The PGT office currently holds about $2.5 million in trust for our clients. And we receive, I would say, between 40 and 50 referrals a year. As Cindy already spoke to, the primary role of the PGT is as the guardian of last resort for incapable adults, providing decision-making in the health, financial, limited personal, and or legal realms, so we can act as the guardian in one, some, or all of those realms. And of course, the principle of last resort is a really key part of our role. All less intrusive options have to have been exhausted. Those I think Lenora already spoke to, and also that family and friends have to have been approached or considered as private guardians. Many times, service providers can also provide as much support as an adult may require. So there has to be clear indication that those services are insufficient to meet the needs of the adult. And that all efforts have been made to meet the needs and the risks, address any risks that have been identified. Which is my way of saying that incapacity alone is not a sufficient reason for the public guardian and trustee to become involved. So incapacity is essential. A person has to be incapable for us to be the guardian, but many people who have finding of incapacity don't necessarily have needs that the public guardian and trustee is able to manage. Most referrals come to us from adult protection services, long-term care, disability services, and the hospital corporation. Although less common, I do receive referrals from existing private guardians. For example, somebody who may be seeking PGT to either take over guardianship or to be an alternate guardian. And a good example of this would be a parent who has an adult child with disability, and the parent is becoming ill or is aging and is looking to set up and plan for the time when they will no longer be able to be the guardian for their child. PGT also has other authorities under legislation other than adult guardianship. We may administer estates, hold money in trust for minors and incapable beneficiaries who inherit money from an estate. I'm responsible for assigning lawyers to represent children in custody access and child protection proceedings. And the PGT must be served with all private guardianship applications and applications to probate a will or an estate when there is a minor or incapable beneficiary. When I'm served those applications, I may become involved in these proceedings if there is a risk that has not been addressed by a private guardian application, or there is no suitable trustee for a minor or incapable beneficiary. I'm going to speak very briefly about some differences in the public guardian and trustee and its role in the Yukon compared to other jurisdictions you may be familiar with. Unlike many jurisdictions, I am not required to act when I receive a referral. Within the PGT Act and the Estate Administration Act and other legislation authorizing my involvement, the language that's used in the legislation is may rather than shall. And I'm part of a very small team that does not provide specialized services or expertise that is common in bigger jurisdictions. For example, other jurisdictions are staffed with lawyers, accountants, financial investigators, and investment specialists. We don't have any of those resources. We do provide lots of supports and information to the public about guardianship and application processes related to both guardianship and estate and applications. We do not prepare those documents for people. We generally provide them with the documents and give them general information about the processes that are required. We used to be able to assist people with those applications, but we're no longer resourced for that, so we're not able to do that. Of course, we also answer lots of questions from other community supports and lawyers about some of those processes that they may be less familiar with.
Thank you very much. Kyla, we're now going to move to Tina Bunce of Adult Protection at Health and Social Services. And Tina is just about ready. Here you go, Tina.
Hello, everyone. My name is Tina Bunce. I am the manager of Adult Protection Services, and that's with Health and Social Services Social Supports Branch. Just to give you a little bit of background, so September 1st, 2005, the Adult Protection Act was proclaimed with the Yukon government, and adult protection workers are mandated to inquire into reports of abuse, neglect, or self-neglect of vulnerable adults. So just a little bit of just who we are. So we're a small unit. We've got 4 social workers, myself as the manager. We work in the Income Support Building. People might know that on 3168 3rd Avenue on the corner of 2nd and Black. And so basically what we do is we're mandated to inquire into reports received of abuse, neglect, or self-neglect. So the caveat there is that it's for folks who are, as the Act states, unable to seek help So part of what we're tasked with is determining whether there are reasonable grounds to suggest that abuse is occurring, and also to determine whether that person may be unable to seek help. So we're looking at specific reports from confidential reporters. And just so you know that the identity of the reporter is kept strictly confidential as per Section 61.7 of our Act. So the other thing that is good to know is that we are mandated to respond to all reports across Yukon. So we do have workers that travel to all the communities and are assigned to the communities. We have one of our workers in Mayo all of this week. We're extremely busy with only 4 workers and the one manager responding to many reports. Certainly, a lot of our reports are in regards to self-neglect, individuals who are losing their capacity to take care of their personal care, just their day-to-day functioning, and as a result are experiencing risk in their life. So part of what we do is if the client is experiencing abuse, neglect, or self-neglect, very much what we're doing is looking at ways we can support them to reduce the risk of harm and increase their safety. So I think it's been discussed a few times. We're very much looking at the least intrusive measures that we can implement to increase a person's safety. So this could involve just making referrals to other service providers, such as home care or mental health services. It could be assisting somebody with some kind of hands-on things with their banking, just to create some safeguards in their life. We do also provide voluntary services to individuals if they are considered able to seek help. However, they're still vulnerable and they may be experiencing abuse, in which case we need to have a signed consent form, and we can provide some support. For the folks who are deemed unable to seek help, we're doing what's called an inquiry, and under that we have several authorities, including seeking information. So we can request information, for example, from financial institutions. We can get bank statements. We can speak to doctors. And what we're trying to understand is what the risk is. We're trying to determine whether abuse is occurring and what we can set up in terms of providing some support to individuals. In regards to financial risk, certainly with individuals who are unable to manage their finances and they require support, and they may be experiencing either financial abuse or exploitation, we are really supporting individuals to as was discussed, the legislation around Enduring Power of Attorney Act is going to be experiencing some changes, which will allow for individuals to viewing. We anticipate that this may increase reports made to our office, just given some concerns around individuals who may be experiencing undue influence, also some concerns around individuals who may not be screened appropriately for their capacity to understand and appreciate the legal agreement. So we certainly will continue to recommend our clientele and the folks that we work with to have those enduring power of attorneys completed through a lawyer. However, as the changes come in effect, we do anticipate to receive more reports in that regard. Yeah, so in terms of what we can do, we have a number of authorities under our act. One of the first things that we will do is we're obligated to make every reasonable effort to meet with the individuals. So our workers are pretty much based in the community. We're going out to see them wherever they may be within their home setting. And we're doing a comprehensive risk assessment around the concerns. And then we're trying to identify how much they understand and appreciate that risk. So in some of the situations, risk can't be mitigated with simple supports being put in place and supportive individuals or decision makers coming in play, or people may not have anybody in their family or friend group that is able to step in that role to support the person with their decision making. And in those situations, we are, consulting with the public guardian office. We are making referrals in situations where it's very much exhausted all possible least intrusive measures with family members, where we make a referral to the public guardian office. Some trends that we're seeing, I thought might be of interest, very much an increase in the number of clients that are reported to our office involved with romance scams. Scammers gaining trust through the victim by, establishing a romantic relationship, and very much preying on people who are isolated and lonely and often housebound. We're seeing these individuals, often claiming to be, movie stars. We've got a lot of Tom Sellecks out there who are approaching individuals, and we're seeing some huge loss for individuals, and it's pretty heartbreaking for families, because usually the money is unrecoverable, despite reports being made to the police and interventions being tried. It can be a really challenging situation. We've certainly seen individuals lose significant assets in these situations. Difficult, even if they have an enduring power of attorney, because it has to be triggered by a healthcare provider who deems them unable to make their own decisions. And in these situations, people can be cognitively intact, and so they're not considered unable to make their decisions, and therefore they are their own decision maker. And what happens is after they, lose their funds, often people lose major assets. There is a whole lot of, kind of depression that goes along with that, and people are quite depressed, and sometimes even suicidal. So we are working with a number of these situations. As I said, they're on the rise. We do speak to the public guardian office sometimes. The individuals do have some more cognitive deficits, where we can look at alternate protective measures, such as guardianship, but it's very dependent on the individual. And of course, capacity is challenging, because we have a number of factors that can cause fluctuations in capacity in terms of mental health issues or addiction. Sometimes that's kind of episodal. So we have to look at their overall capacity. Another thing I just wanted to mention, I thought was interesting, was enduring power of attorneys, where we see lawyers who include the health domain. And Lenore had talked about advanced care directives and the forms that are available for individuals to complete, with their healthcare provider, because they are very much health-orientated forms. There's a number of things on there, including resuscitation wishes and end of care wishes, that really are best completed with a doctor who has the knowledge and the expertise in that area. And what we do find is that the enduring power of attorneys that include the health on there, they do tend to cause quite a bit of confusion for folks. Basically, our office is mandated to respond to reports of abuse, neglect, and self-neglect. And we very much work to help, promote safety and reduce the risk of harm. A lot of what we're doing is kind of hands-on work with individuals, and very much trying to connect them with service providers. Under our authority to request information, I should mention that there is an exception with client solicitor privilege information. Having said that, there are clients that will sign a release of information for us to speak with their lawyer, which can be very helpful in situations to better understand, their situation, their enduring power of attorney, and just overall decision making.
Thank you very much, Tina. It's now question period.
Okay, we got a question from Lee. Can Section 6.3 declarant under the Enduring Power of Attorney Act be the person or one of the people assuming attorney powers under enduring power of attorney? And the answer to that one is yes. In fact, it is. So it specifically says in the Enduring Power of Attorney Act that the person who's making the determination of incapacity can be the attorney. Got a question from John. Is there any provision, protocol, or practice for the appointment of an advocate for the subject of the guardianship application if the subject is opposed to the application? So that's a question for Cindy. I think you could just maybe,
Yeah, sure.
or can you sit over here? And I want to apologize to everybody who's watching because we have been really struggling with the technology today. And furthermore, I have to mention, it's weird for us too because we can't see anybody. So we're just looking at it.
There are certainly situations across the country where adults do have a separate representation, and this can be in contentious applications, or the court itself might want a lawyer appointed for the adult. But generally, in most situations, the adult is not represented when as it gets more contentious. And if the adult is resistant, then the adult might be represented.
I want to say that I have represented a couple of times an adult who was found to be incapable. And so I was the independent lawyer. And as I've expressed to the public guardian and trustee recently, it actually puts that lawyer in an extremely challenging position because they, in the one case in particular, where the adult was being financially taken advantage of. But it was by somebody that they considered their friend and were very, very fond of and were really resistant to advice from me about sort of creating some barriers with that individual. And so it's especially if you have an adult who doesn't consider themselves to be incapable, which is often the case, then it's the lawyer representing that person can be in a very different position. Next question, Jim Tucker. The Care Consent Act has a test for determining incapability to give or refuse consent in paragraph 6. Why don't they use that? I'm going to hope that Cindy's got that legislation.
From a practical perspective, there is a guide, just like there's a guide for determining incapability under the regulations for the APDMA for guardianship applications. So in the APDMA, it says that the incapability shall be determined in accordance with the regulations, and then the regulations speak to this guide, and then the guide sets out the regulations, and I'll just pull it up. There's one for under the Care Consent Act too. Now, I haven't, or I don't remember off the top of my head exactly what the test is, but there certainly, when it comes to healthcare and consent, it really is talking about a specific decision that's right in front of the healthcare provider at that particular time. When they're doing incapability assessments, it's much broader than that. They have to look at the needs of the adult, what kind of decisions they'll have to make in what kind of areas, but it's not about should this surgery take place or should this medication be issued. So it's just a different context. But yeah, I mean it wouldn't apply. You can't just take that test and apply it to a guardianship situation. Deborah, if you were asking about the certificate of financial needs, that's under section 61, the need for financial protection. That's under section 61 of the Care Consent Act. And those are issued by healthcare providers, and they're issued when a person is incapable of making a healthcare decision and also managing their financial affairs. They need financial protection. They fill out those forms. They send it off to the public guardian and trustee, who may issue a declaration of statutory guardianship, which allows her on the spot. So that's without court oversight, to become the financial guardian of a person. And that can be challenged. There are provisions under the Public Guardian Trustee Act if someone wants to challenge that. But that's not really about financial services assistance. 102 and the Public Guardian Trustee and the Adult Protection Service both investigate allegations of financial abuse. I'll just clarify that the Adult Protection Services authorities are found under the Adult Protection and Decision Making Act at the end of the act, so under the same act as guardianship. And there is a provision in there where a designated agency, which is the Adult Protection Service, Adult Protection Services, can make applications for protection orders, and those may also be relevant to your clients at some point.
I'm just picking up on what Tina touched on, financial exploitation of marginally capable. What is the PGD doing to protect citizens from predatory marriages and other arrangements? Are you doing anything about that? I could probably turn this around.
Probably the straightforward response is that the PGT only has authority to act when we have authority to act. So we have very rarely any involvement in marriages or divorces. I don't believe we, to my knowledge, have ever been granted the authority in a guardianship application to proceed with a divorce. In fact, in one recent application, we had specifically requested that authority and it was denied. So we're not involved in marriages. I'm not quite sure how we would proceed if we had a request for a current adult who was under our guardianship to get married. That's one that I would be very much consulting with my legal counsel on. But yeah, we don't play a role in monitoring people's marriage. We have there's a presumption of capacity that applies to all Yukoners, that people are presumed to be capable of making their own decisions, and our office only becomes involved when it's demonstrated that they have incapacity to make those decisions, and then our role is very limited, and the personal lives around pursuing or ending a marriage is not something that we enter into lightly.
I could just add to that these situations do arise in the context of guardianship applications. So sometimes Kyla might have a file where someone is already married and it is the spouse who is perhaps an attorney and is not complying with her duties as an attorney during power of attorney, or is engaging in financial abuse of the adult. And it gets very messy and contentious.
Do you prefer, this is Gareth, do you prefer an enduring power of attorney that continues to be effective after incapacity, or one that becomes effective on incapacity? So that is a question that I'm asked quite often. When my clients are people who are quite elderly or have serious healthcare problems, if they are anticipating that in the near future that they might need an attorney and need an attorney to act for them, then at that point I actually do at least discuss with them the possibility that they make it effective immediately, and sometimes they're happy to do that, and I'm going to say almost always their families are happy to have them be making that decision, and it saves that entire discussion about incapacity. I'm going to mention that in the Enduring Power of Attorney Act that I make for clients, I actually have two options. So one is that they are determined to be incapable and needing the enduring power of attorney to be effective for that reason. But I make it, and I know that a lot of other lawyers do this as well, is that I make it possible for them down the road to make a decision. So this has to be while they are still capable, that they can make a decision that they simply want it to be effective. If you've got somebody that is housebound, for example, in particular, or has some serious health problems, they might then, but they have to make that decision while they are capable. So I at least put it out as an option for everybody. And I've had people come in and say, oh, it's so much trouble getting this incapacity assessment done, and sometimes doctors are reluctant to make those determinations, and so they'll say that yeah, they want it to be effective immediately for that reason. And this is Deborah clarifying it was the last speaker from adult protection, so that's Tina. Also, can anyone speak to services provided by the adult behavior team? So I believe it's the name.
I know there is an adult behavior team within the long-term care facility, specifically for residents within long-term care to deal with managing behaviors. Is that the question? Services private behavior team. Yeah. So I think within the care facilities with really challenging behaviors, I think there's more individuals coming into continuing care with complex behaviors, individuals with maybe requiring managed alcohol programs. And so they have a support team that can deal with more complex sort of mental health or substance use or other challenging behaviors that may be associated with dementia or other neurological disorders. I should just say quickly, because I think Cindy, you touched on it too. Adult Protection Services has a number of other authorities, and with the short time limit, I didn't go into a lot of depth with that, Tom, and I do have a good overview that I can provide as a handout if you'd like to link to it. Just providing some of our authorities. So very much least intrusive, we're going to provide support to individuals as much as we can to reduce risk of harm. And if the situation warrants, we do have authorities such as emergency assistance, where we can do a number of things, including, to convey somebody to a place of safety under Section 78 of our Act. That's something that we utilize quite frequently. We work very closely with the RCMP, with the Paramedic Response Unit. We work very closely with CAR 867, which is a mental health and RCMP team in those situations. So I just wanted to put that out there. There are a lot of other tools that we have in our legislative toolbox that I didn't review. Just kind of wanted to give an overview of our mandate. Thanks.
We've got 3 minutes left. Can I just say, let me say something first, Tom? So I just want to say, with respect to the planning tools, I actually am a huge proponent of these planning tools. Cindy went through all of the things that are involved with the guardianship legislation, so that's good legislation, and there has been a big effort made to make it, comprehensible for people. But it's still actually a huge and pretty onerous process, and furthermore, it's an expensive process as well because of the bare minimum you have to pay to get an incapability assessment conducted. So when you are talking to clients, especially older clients, I highly recommend that you at least recommend the possibility that they investigate an enduring power of attorney and an advance directive. It will potentially save their families a great deal of grief. It potentially saves them from financial abuse by people that sort of step in where there's a gap. It can save a great deal of money. It means they're choosing the person that they want to make decisions for them. It's true that maybe most people will never need one because they're not going to have this period of time when they are alive but incapable. But if they do, it is a huge problem if they haven't made this planning decisions ahead of time. And we've got an aging population here in Yukon, and even if this is not the kind of work that you're doing yourself, you should be aware of what the options are for people so that you can refer your clients accordingly. And I'm going to pass it back to Tom.
Well, thank you, Lenore, and thank you to all the participants for your many questions. We're now almost at the end of today, and I'd just like to acknowledge our speakers today. It's quite obvious that Tina and Kyla and Cindy and obviously Lenore have a lot of knowledge in this area, both the legislative piece and also the implementation of the legislation and how that works through the Adult Protection Office, for instance, or the Public Guardian and Trustees Office. So thank you very much for that. I'd also like to thank the Professional Development Committee of the Yukon Law Society for yet another presentation. And of course, to Lynn and other members of the Law Society Yukon office for the technical support. We had some challenges today, but that's just the way it goes. And once again, for all of you for tuning in, I guess we can say from coast to coast because we had at least one participant from the Atlantic side. Thank you, Deborah. And of course, we're very close to the Pacific here. So thank you. And if you want to see this again, the recording will appear on the Law Society website. And I hope you have a good rest of your day. Take care.